Assalamualaikum warahmatullahi wabarakatuh. Inshallah today our group will be presenting the issue on the topic of defamation, whether the Derbyshire principle is applicable in our country.
So we begin with the summary of the news. We have found the news in 2022. The hearing of federal court maintains government can sue and be sued for defamation. So the federal courts, in this case, however, in a unanimous decision, the apex court rules that political parties cannot sue individuals for defamation as they do not have a reputation to protect law. So in this discussion, we will distinguish between the Derbyshire principle itself and our Malaysian law. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Abdul Rahman Mukris bin Harun with matric number 2315001. So firstly, we are going to discuss the first case, which is Chong Chen Chen and Government of State of Sarawak, and another 2019 with citation 3 MLJ 300. The parties involved in this case were two. Number one, the appellant, which is the Chong Chen Chen, and also the respondents, the state of government of Sarawak and department or organ of that government. So moving on to the material facts of this case, the appellant Chong, the opposition state assemblyman as well as the member of parliament had alleged that the financial affairs of the Sarawak state government had been mismanaged to the extent that the disappearance of close to RM 11 billion in state funds had not been explained. And his allegations were published in a daily newspaper, published in the leaflet of his political party, as well as in an online portal. Consequently, the respondents sued him for damages, claiming that Chong had defamed them. So, in any event, Chong said under Defamation Act 1957, Article 10 of the Federal Constitution, and on grounds of public policy or public interest, the respondents had no locus standi to sue him for defamation. The High Court was in favor of the respondents regarding the most critical question, which is whether the respondents had the right to sue him for damages for defamation, relying on the decision of the House of Lords in Derbyshire County Council and Times Newspaper Limited and others, the Derbyshire principles that we are going to discuss in this scenario. So the High Court held that although a state government or a statutory body could sue and be sued, they did not have a right to sue for defamation. By a majority, the Court of Appeal reversed the High Court's decision on that question. Therefore, the majority rejected the appellant's argument that government and its bodies had no reputation that needed to be protected by the law of defamation, holding that a government's reputation could be injured by libel if the impugned words tended to lower its reputation in the estimation of right-thinking members of the public or exposed it to hatred, contempt, or ridicule. Moving on to the legal issues and cause of action of this case, we have extracted two issues from the case, which are number one, whether government or government body had the right to sue an individual for damages for defamation. And it covers the area of the distinguishment effect between our Malaysian law itself, the Government Proceeding Act 1956, with the common law principle, thereby Shire principle. And the second issue would be whether federal or state governments, like natural persons, has a reputation which was capable of being defamed. Therefore, the cause of action in this case is defamation. The government of the state of Sarawak and another respondent brought defamation lawsuit against the appellant, alleging that he made statements that harmed their reputation. So, lastly, we discussed the judgment of this case. Unanimously, it was held that to affirming the Court of Appeal's majority decision that the respondents had the right to sue and maintain an action for damages against Chong. So, in this case, the reason behind the decision would be for number one, governments. We are going to refer to the government's right to sue for defamation. Number two, statutory interpretation of the government proceeding acts, and also number three, application of common law in Malaysia, and lastly, freedom of speech and defamation. So, firstly, government's right to sue for defamation. The court held that under Section 3 of the Government Proceeding Act (GPA), the government has the statutory right to initiate civil proceedings, including defamation actions. The court interpreted written law as defined by Interpretation Act 1948, determining that it does not include the common law of England. Consequently, the common law principle from the Derbyshire case, which precludes government bodies from suing for defamation, does not apply in Malaysia. Number two, statutory interpretation of GPA. The court interpreted the GPA, particularly Section 2, Subsection 2, and Section 3 to mean that the federal and state governments are entitled to sue for defamation. The court concluded that there is no provision in GPA that prohibits or restricts the government from pursuing such actions. And number three, application of common law in Malaysia. When determining the applicability of English common law principles, the court must first consider any existing Malaysian written law on the matter. Since the GPA provides a specific statutory framework for government legal proceedings, including defamation, the English common law principle does not apply. And lastly, number four, freedom of speech and information. The court reaffirmed that the right to freedom of speech and expression under Article 10, Subsection 1A of the Federal Constitution is not absolute. It is subject to restrictions, including defamation laws, as outlined in Article 10, Subsection 2A.
The next case we can refer is Lim Guan Eng against Ruslan bin Qasim, where in this case the appellant Lim Guan Eng, who was the Chief Minister of Penang, made a 2-day official visit to Singapore for the purpose of attracting investment. And in the course of the visit, he had attended a dinner with some Singaporean politicians. The respondent Ruslan bin Qasim issued a press statement where he alleged that the appellant might have leaked some national secrets to foreign parties, and then he questioned the appellant's loyalty to Malaysia. So the appellant sued him for defamation, and in the High Court, he win the claim. However, the claim was then be dismissed by the Court of Appeal on the ground that he had no local standby to sue for defamation in his official capacity as the Chief Minister of Penang. So the appellants brought the case to the Federal Court for appeal, and then he raised the decision made by the court in Chong Ching Jen against government of Sarawak. And then he argued that since Chong Ching Jen allowed a government to sue for defamation, then by extension, he as a public official should have the similar right to do so. So, the issue in this case is whether the federal court's decision in Chong Ching Jen against the government of state of Sarawak allowed a government official to sue for defamation in his or her official capacity. Okay, so moving on to the decision of the court. The federal courts in this case decide that the case in Chong Ching Jen was not applicable in this instant case. This is because the case was about the rights of the government of Sarawak to sue for defamation. However, in this instant case, it talked about the rights of individuals, albeit as public official, to bring such proceeding. Hence, the Chong Ching Jen case of no existence to the appellant and was irrelevant. Nevertheless, the court still allowed the claim on the ground that he made the claim under his personal capacity. And lastly, the ratio decidendi in this case is a public officer when suing an individual as individual, whether he was suing in his official or personal capacity, was not prohibited from bringing an action for damages for defamation. So, to put it in the simplest way, everyone can sue for defamation, whether he sue under his personal capacity or as a public official. But if he sue under his public official, he must be represented by a lawyer from the government.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Rafiq bin Umar, and I will be the one to present our commentary on this issue. So the rule that was used for this issue is defamation. However, the specific issue for the cases that need to be highlighted here is whether the Derbyshire principle is applicable in our country. For starters, the Derbyshire principle refers to the principle that said the government body cannot sue for defamation, grounded by the idea that they should open to scrutiny and criticism as part of democratic accountability. In our opinion, we unanimously agree with the decision of the court that held that the Derbyshire principle is inapplicable to our country. Our opinion is based on two reasons. The first reason is to keep the public morality. This is because if the Derbyshire principle is applied in our country, the citizens will freely utter and say any words they want, without being liable rather than giving fair comments, hiding behind the power of freedom of speech. Actually, this is not intended to limit the right to freedom of speech, but rather to allow the government bodies to redress any defamatory statements that was made towards them, to maintain their reputation to society and other country. especially if the statement is false. Other than that, the spreading of false information also can be controlled. The second reason for the inapplicability of the principle in our country is because the presence of the written law. As an example, in the case of Chongqing the principle cannot be applied because of the presence of the Section 3 of Government Proceedings Act that says that the government body can sue with their own capacity. As we know, our country adapted its law from common law. But by the time the law of our country has evolved, and as of now, the statute that governs the law of defamation is Defamation Act 1957. And there is nowhere said that government body cannot sue with their own capacity. Moreover, there is even written law that allows them to do so. Although in the case of Lim Guan Ang, he cannot sue with his capacity as public officials, the Defamation Act does not state anything that prohibits him from suing with his personal capacity, which in this case he did. Therefore, the judge must prioritize the law of our country before using the principle from common law. All in all, the court made the right decision by protecting the public morality and written law of our country while upholding justice to the righteous party.
I think that is all from us. Thank you and Assalamualaikum warahmatullahi taala wabarakatuh.